2 weeks ago, and he was under cross-examination. And counsel for accused number 5 intimated that he needs further information before he could proceed with his cross-examination. Lieutenant Colonel Hose then went and compiled a further statement which we have marked Exhibit DD 5 in brackets B. The court will recall that Exhibit DD 5 is his original statement. Then there's Exhibit DD 5 in brackets A, which is a supplementary statement correcting certain errors in his affidavit. Then there'll be Exhibit DD5. Exhibit DD5 is his affidavit that shows communication between the various accused. Then when we adjourned at the previous occasion, we indicated that we have received the correlated data of accused number 3, which we then shared with my colleagues. And Colonel Hose then went and compiled a further affidavit arising from the call data of accused number 3. And this morning he has finished us with that additional statement, which we will mark Exhibit DD5 in bracket C. I've shared this affidavit that was received this morning with my colleagues, which no more than reflects the calls that are in the call data of accused number 3. I haven't received any indication as to whether there'll be any objection if we proceed. I'll just take my seat just to find out if my colleagues...
When did you finish this extra information, additional information?
When it was received this morning, my lord.
This morning?
Yes.
How many pages is it?
It's 6 pages plus an annexure. But as I've indicated, my lord, it does no more than reflect the information that is already contained in the correlated data that was furnished to my colleague some time ago.
Is that the one which was finished in October? In the disk?
No.
Not that one?
It was finished about a week ago, my lord.
Okay. And as I understood it, Lieutenant Post also had to go over Colonel Stein's affidavit.
Indeed, my lord.
He has done so.
Yeah, he has done so, and that information, it's in a way reflected in Exhibit DD5 in brackets B.
Okay. And the SMSs, Mr.
Well, the SMSs, my lord, the handset was not downloaded, so we did not have those SMSs, and I explained that to Advocate Malo.
Are they available or are they not there?
Well, the phone was not downloaded. They are not available.
They are not available?
Yes.
Does Mr. Ngumalo accept that position?
Well, I've explained that to him, my lord.
Yes, Mr. Ngumalo, what's your view?
I would like to confirm that it was explained to me that SMSs are not available. I thought maybe there would be a change of circumstance to the MITech instructions from the accused. I thought that there would be a change of circumstance from the last occasion when this information was related to me.
No, but there's a difference between not available and not existent. As I understand, Mr. Baloyi, that information of the SMSs does not exist. Am I correct, sir?
Exist.
Yes, indeed, as indicated.
It's not
Yes.
available, because
Yes, for-
if it's not available, it possibly can also be existing.
Yes, but 2014, my lord, we don't have those SMSs. We only have the phone of accused number 3,
Right.
and we don't have any SMSs for that period.
So the service provider has destroyed it. Or what?
Well, as we've indicated, my lord, that the phones, the accused were only arrested in 2020, and the data on the service provider network is only kept for 3 years.
3 years, you say.
Yes.
Right.
So we don't have data preceding the 3 years.
3 years.
Yes.
Yeah, but what happens to that data from the service provider? Does it destroy it? Does it put it into archives?
Yes.
What does it do with
Yeah,
it?
well, it's basically destroyed. You know,
Destroyed.
obviously they cannot keep all the data, my lord. They have to make space for, you know, for
Yeah,
other
but lawfully
data.
or legally,
Yes.
how long have they got to keep the data?
Well, my lord, they say for 3 years.
3 years.
And if they receive a request from law enforcement agency, they'll then extract the data from the network
Right,
and then preserve it on their server in a PDF format.
right.
And if that information is then requested, like in the case of accused number 3,
Right.
then they have it on their server and it can then be furnished.
So, did you request it? As you're explaining.
Yeah, well, it's not available, yes.
It's not available.
Yes.
They tried to trace it, it's not available.
Yes.
Any comment again, Mr. Numan?
I have no comment except to request indulgence to
Hello?
accept the indulgence to approach Mr.
Yeah,
Marcus
yeah.
and
Yeah,
inform
approach
him
the
of
client.
position. Yes.
Yeah,
yes,
let's
thank you.
go. Your comments, Mr. Numan? After you.
Thank you, my lord, for the court's indulgence. My client accepts the position
Okay,
that
fine.
SMSs are not available.
All right, Mr. Gomezulu, any comments regarding what the prosecutor is saying?
My lord, I confirm that I've received the 6-page exhibit DD5C, my lord, and I have indicated that we are ready to listen to the evidence of Mr. Holmes, and if needs be, we will consult with our clients in due course.
Okay. Mr. Ramsepi?
If it may please the court, my lord, I also confirm receipt of exhibit DD5 in bracket C this morning. Now, regarding what Mr. Advocate Numalo was requesting, my lord,
Yeah.
I think that's a matter that can be ventilated by a representative of the mobile service operator, because I have done a case previously whereby records of over 3 years, they don't rot, my lord.
They don't?
They don't rot.
They
They are
don't rot,
archived.
I see.
They are not disposed of.
Ah.
In our evidence, we were told that it does take longer because they are in the archives to retrieve them, but they are retrievable, my lord.
So where are you going to get them? Because Mr. Baloyi says the service provider cannot trace them. He told him they are not available, they are non-existent.
My lord,
You've got other sources to get them.
His Lordship made a poignant distinction, availability and existence. They say the phone was not downloaded for messages, yet the phone in 2014 was downloaded for this data in exhibit DD5C.
Mr. Baloyi?
If I can maybe just clarify what Mr. Ramsipil is saying. even for argument's sake, even if data was, the SMSs were available, which we say we are not, the service provider cannot see the content of the SMSs. All that they can see is that A sent B an SMS on this day, but the content
The content.
cannot be seen. So the service provider will not have that information, the content of the SMSs. It's only upon downloading of the handset that those SMSs can be retrieved.
Okay. You understand it that way, Mr.
I do understand it that way.
You accept the position.
I do accept this qualification now.
What do you want me to do? Issue an order? I can issue an order
My lord, that
to the
is
service provider so that they officially respond. If you think or you say the state, I don't know, it's not playing open cards or completely open cards with you and Mr. Nguman.
As my submission was saying, this point can be ventilated because apparently a representative from the service provider will come and testify. Then he can be probed on that aspect, whether they are archived and they can be retrieved in what format.
Well, according to Mr. Baloyi, he
Yes.
has already been told after the probe. Am I right, sir?
Yes, my lord.
That this is the position.
Then I can't take it any further. my lord.
Can you listen? Any comments?
As it please the court, I do confirm receipt of the test affidavit. That was apparently going to be marked as a court exhibit 85C.
Okay. Mr. Nguman?
My lord, I also confirm having received additional information.
You are what?
Exhibit DD5.
You confirmed it?
I confirmed it. And the issue of SMSs, I think it has been put to rest, so we have nothing further.
Okay, Ms. Shona?
I have no submissions.
You have thought?
I have no submissions.
No submission.
No.
Have you received the information? All the information? That's what I'm interested in. Which you pertinently said you are being ambushed with. You
Yes,
remember
Yes, I've received.
your assertion?
Yes.
Yes. Now you say you have no submission.
No, but I'm saying I've received it.
Okay, fine.
Thank
That's different from saying I have no submission. Okay, so we recalling Mr. Host in terms of section what?
Oh, well, he's still under cross-examination.
Yeah, but you
I just
remember?
number 4,
Yeah.
yes, but I'm just thinking, just to do justice to the criminal procedure,
Yeah.
how we should go about for him to put the information on record. Our suggestion would be that the additional affidavits are handed up and that as an expert, he just continues to put the information on record. Then if any of the counsel have got cross-examination starting from accused number 1, Mr. Mgomezulu, then they can do so.
Now, this thing is buried. We had agreed that he'll be recalled and the additional evidence will be led by him and all the annexures, and thereafter he will be cross-examined from the beginning of his evidence when he says that is it necessary?
That's correct, ma'am.
Yeah, but we've got to justify that in terms of the code,
Yes.
because once a witness has testified and has been cross-examined, it's different from a witness who testifies and thereafter is cross-examined and it ends there. But when the witness comes and says there's additional information after he has been cross-examined, then the parties should agree. But I think it's section what, 167, Mr. Mgomezo.
Section 167.
Is it so, Mr. Nisi? Section?
167.
Is it 167, Mr. Cholo?
Well,
Well, 167 says the court may at any stage.
My Lord, 167, it
Yeah.
says the court may examine the witness or person in attendance.
Who has been subpoenaed, blah, 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 such proceedings in attendance, da, 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 including an accused. Oh, yeah, well, it says this, including an accused already examined at the proceedings, and the court shall examine or recall and re-examine the person concerned if his evidence appears to the court essential to the just decision of the court, of the case. So this covers it, ne? What's your view, Mr. Nguman? You quiet.
yeah. we must just keep in mind that the cross-examination is still ongoing.
Yeah, it is, but he's going to testify de novo, in other words, of the new evidence. And thereafter it joins the old evidence on top. Then to be fair to the defense start the cross-examination from the beginning of your evidence, even if you have been cross-examined prior. Okay, so that's how we proceed. Are we agreed, all of us?
As the court pleases. Then previously the court asked the state to lead the evidence, to lead a witness when we dealt with the...
Yeah, remember.
Yes,
With Mr. Dupree.
Yes, when he dealt with Mr. Dupree.
Yeah, fine.
The state was
Yeah,
more than
okay.
happy to lead.
He can't just stand up, Mr. House, even if he's an expert, and start saying, you know, Mandela did this and this. You've got to lead him. Are we agreed?
No, we're not in agreement, my lord.
So what do you suggest we should do, Mr. Shoro?
My lord, the state had finished leading evidence in examination in chief. When the questions arose of whatever evidence that was being requested, my lord, the state had already finished the examination in chief.
That's what I understand it. Did you lead all the evidence in chief?
Well, there is so, my lord.
And then what happened thereafter?
And the defense started with cross-examination.
Right.
Mr. Mgomezulu conducted his cross-examination
Right.
and finalized it. Then Mr. Ramosepele, Advocate Nesi.
Right.
Then when it got to Advocate Numalo, he then indicated that he needs further information.
Information, right?
So it is at that point, my
Yeah.
lord, where the proceedings were then adjourned. Hence, I was suggesting that perhaps Colonel Hos can just merely put the information on record.
Which he did not put
Yes,
on record in his evidence in chief.
yes.
Is that not so, Mr. Shoro?
Thank you, my lord. At least the state has clarified this.
I
that-
clarified it.
Thank you, my lord. At least the court has clarified, my lord, that the state had finished
Yes.
its examination
Right.
in chief. Now we're in the middle of cross-examination when the information was requested, my lord.
Right.
And therefore, after the witness has been able to secure the information that was being requested,
Right.
then the cross-examination has to continue.
Then this witness must adduce evidence regarding the evidence which he had to get in hand. Is that not so? Then thereafter you all start your cross-examination from the beginning. Nobody is prejudiced.
No, my lord, at least I've placed
No,
it
Mr.
on-
Chalolo, you don't understand.
At least I've placed it on record, my lord.
Wait. You see there are new affidavits.
Yes, my
3 of them, is that not so?
Yes, two in
2, and they're made by Mr. House.
Yes.
How do we get them on record?
My lord, the examiner will lead the witness according to those evidence and according to those statements
is
that
that
have
not
been...
evidence then? That's Baloyi leads this witness on the evidence which is encapsulated in the affidavits, the new affidavits. Is that not how you understand it?
No, my lord, we've got different understanding. I'll rest my case, my lord.
Okay, and this is
May I,
yeah, okay.
may I make a submission?
All right.
The court will recall that actually I had not finished my cross-examination.
I know.
Yes.
Yes.
Now, subsequent to the cross-examination of Mr. House being pended, it transpired that there is a new information that the state wanted to put on record,
Right, fine.
as if that is evidence in chief.
Right.
So what I suggest should then happen now is that we should finalize our cross-examination. If there is any further new information that the state would want to put on record through Mr. House, then the state must make that application to recall Mr. House and put that new information into record, and then we all then get afforded the opportunity to cross-examine him on that new evidence. As opposed to the state...
Okay, fine. Now this new evidence, is it going to be recorded in this court?
That will depend on the application that the state is going to make in recalling Mr. House to put that new evidence on record.
Now, according to
because
you-
this is new evidence
to you,
altogether. It's not a continuation.
Listen, your submission is the cross-examination of this witness should continue from where you ended
Yes, madam.
up to Ms. Msholo.
We finalize
And
it,
what
yes.
happens thereafter?
Then the state makes an application to recall Mr. House to
No, but
introduce that
this
new
witness, this is the
evidence.
problem you have. This witness, once you are cross-examining him,
Yes.
he may refer to these affidavits. Am I right, host?
That's correct.
I'm long in the game. And how do you have recourse to these affidavits when he refers to them there, when he hasn't led them in chief in terms of 167? Are you with me?
The challenge, my lord, in that regard is, it has never happened that a witness was under cross-examination at the same time is also led in evidence in chief. It's a very precarious process because
Okay,
the cross-examination must be done up until the end,
I've done it a million times, fine.
as it please the court, madam.
And
Thank you.
it's lawful, by the way. Continue with your cross-examination then. They say if you want to, you will recall this witness.
To me, it's really compartmentalizing the issue.
Then fine, but the general principle is, if a witness proffers an answer to evidence which he hasn't led in chief, but which he has subsequently deposed to in an affidavit, he can refer to it. You can't stop him and say, you didn't say that in chief. Please, I'm making that ruling.
Yes.
Right, let's continue then.
Yes, just maybe one point. The fact of the matter is the defense criticized the witness for not having shown communication between the accused. Now, he has done that, and I think, to me, the practical solution would be for him to then place that information on record to say, listen, we have since gone and compile that information that the defense has requested, and then everybody gets opportunity to cross-examine. That will, in my view, be a practical solution.
Mr. Gomezulu, I see you're shaking your head.
My lord, I would actually make a submission to concur with Advocate Mnesi in the sense that basically, and what is a principle of law relating to these procedures, it relates to prejudice. My submission is that I concur with Advocate Mnesi. Let the cross-examination proceed as it has carried on, because that's when, if the state brings the application now to listen to the new evidence, that's when the defense will determine whether there's prejudice against the accused.
I've also heard, Mr. Mnesi. Have you ever in your career heard of a court recalling a witness? Have you ever heard that?
Yes.
Not even consulting the defense.
The court, yes.
Yeah, it's section what? 167.
It's 167.
Then the court can re-examine that witness on the evidence he has said. In other words, I can say, are you aware that in terms of the principles of analyzing cell phone information, you can do A, B, C, and D? I can do that. And it's not me. It's this book. Let's read it. The court may, at any stage of criminal proceedings, at any stage, the court, examine any person other than the accused who has been subpoenaed to attend such proceedings or who is in attendance of such proceedings, and may recall and re-examine and other proceedings, and the court may examine or recall and re-examine the person concerned if his evidence appears to the court essential to the just decision of the case. That's what it says, not me. But we'll do it the way you suggest.
Correct, madam.
And then me, after that, I'll do it in terms of section 167. Okay, continue, Mr. Nisi.
Is it please the court, madam?
Yes, no.